Hi, I'm Mike Greiner. I'm a bankruptcy attorney with the Financial Law Group located here in Warren, Michigan, and I'm here to talk to you today about the automatic stay in bankruptcy. This is one of the most powerful protections that people have available to them as they're going through bankruptcy. Virtually any other process that you deal with, your creditors are still going to be able to garnish you, they're still going to be able to sue you, they're still going to be able to create all kinds of problems in your life, seizing assets and anything like that that people really aren't even aware of. For example, let's say that you went to court and you've got a creditor who's got a judgment against you for a certain amount of money. You go to court, you ask for an installment payment agreement. Say the court grants that request. Now that request does protect you from them garnishing your wages, but it does not protect you from the creditor coming after either your bank accounts or any other assets. They could file a lien against your house, they could file a lien against any other property, and they could have the deputy sheriff show up at your house and seize the vehicle. So that's not a protection that's available to you, even though you have this court order saying that you're making installment payments on this debt. There's also the debt consolidation companies that you hear about all the time, where they make promises that they can stop the harassment and the phone calls and the lawsuits without you filing bankruptcy. And the fact of the matter is, most of these companies do not provide you with any protection at all. In fact, the law does not give them any ability to give you any kind of protection, and most of the companies tell you to stop making payments to your creditors outside of their program. And as a result of that, a lot of the time you'll see that these credit card companies will come and sue you, even though you're making payments to the debt consolidation company. So there's no protection there either. The only way that you can actually get true protection from your creditors is by filing bankruptcy. Because when you file bankruptcy, there's a provision in the bankruptcy code. It's 11 U.S.C. section 362. And what that provision says is it says that no creditors, once you file bankruptcy, from the minute you file bankruptcy, no creditor can try to collect on a debt from you. Now that would include a creditor trying to garnish you. That would include a creditor trying to have the deputy sheriff seize assets from you. That would include a creditor trying to file a lien against your real estate. Any of those things are barred as soon as you file the bankruptcy. What's more is oftentimes if you've been garnished over a period of time, or if you had a lien placed on your house relatively recently, what we can do is we can go back and undo those things and even get you back some of the funds that have been garnished from you during the period before you filed bankruptcy. That's a big surprise to a lot of people, but it is one of the powers that's available to us under Section 362 of the Bankruptcy Code. So if you've been dealing with some of your creditors and you're really getting frustrated with it, please feel free to give us a call. I'd be happy to meet with you personally to discuss some of your options. We're conveniently located on Hoover Road in Warren, just north of 12 Mile. We're easily accessible off of 696 into Oakland County, Wayne County, St. Clair County, or Macomb County. Our phone number is 586-693-2000. Our website is financiallawgroup.com. I'd be happy to meet with you personally, even on evenings and weekends.